But first up, Cardinal George Pell. He's been acquitted of child sexual abuse convictions by the High Court of Australia. And I know I don't have to say it, it shouldn't need to be said because it goes without saying, but my interest in this matter is because I care about victims, I care about justice, I care about the truth. And that's precisely why we're talking about it today. It is to that end that we discuss the fact that the Cardinal has been acquitted, and it's not that he got off on a technicality. This was not a legal mumbo-jumbo outcome. This was a unanimous decision of 7 judges. It was clear, it was decisive, it was sharp, and it was authoritative, and it exposed fundamental gaps that should not have been there for such a superior court in the Victorian Court of Appeal's judgment. It highlighted a wide range of errors of both fact and law. This was about as powerful a rebuke as what the High Court can give to the Victorian Court of Appeal, and it addressed serious failures. The High Court said that there was, quote, there was a significant possibility that an innocent person has been convicted. Why? Because the evidence did not establish guilt to the requisite standard of proof. Now that's the fundamental point that flows through the entire judgment. And it is a fundamental point in a criminal case. It rests on the fact that guilt must be established beyond reasonable doubt in light of all of the evidence. That's the standard of proof. And the High Court said that the jury in this case actually must have entertained doubt in light of all of the evidence. It's a strong statement. They said that the Court of Appeal must have also entertained doubt, a big call. I quote, they said that their honours, that is the Victorian judges, reasoned to satisfaction of the applicant's guilt by discounting a body of evidence that raised lively doubts as to the commission of the offences. Strong words. This is what Pell was accused of. Just to go through the detail for a second. The allegations were that it was Sunday Solemn High Mass on December the 15th or December the 22nd, 1996 at St Patrick's Cathedral in Melbourne, and George Pell was the newly installed Archbishop. The Mass concluded, and the choir and the servers made their usual procession towards the front door. And at that point, Pell and his MC, Charles Portelli, would customarily stop and they would spend about 10 to 30 minutes greeting parishioners. Now, for some reason, the allegation is that on this day in question, he must have been able to break away from that or terminate it early so that he could commit the crime. But in any event, the choir and the servers, in their usual custom, processed out the front and around the side of the cathedral to the back, where they entered some rooms. The rooms have technical names, don't need to know them. A normally busy area, though, where choir, priests and others would divest, where articles of worship that were used in the Mass would be stored away and cleaned and all that kind of thing. Now, 2 choristers broke ritual and escaped from the procession, entering those rooms through another door. In the priest's sacristy, which is one of the rooms, they encountered Pell, who the allegation is raped them over a period of about 6 minutes. One of those boys was Pell's accuser. The jury found the accuser compelling in his recounting of those events, and the Court of Appeal agreed. That's why we ended up in the High Court of Australia. But the High Court was at pains to point out that the alleged victim was not the only credible witness. There was actually quite a number of credible witnesses described as honest, as compelling, as credible, and as unchallenged. And that was the important point, unchallenged. There was Charles Portelli, Master of Ceremonies, Max Potter, the sacristan, Daniel McGlone, altar server, Geoffrey Connor, altar server, Peter Finnegan, cathedral choir marshal, Anthony Nathan, choir boy, Luciano Parisi, choir member, Andrew LaGreca, choir member, Rodney Deering, adult choir member, David Deering, choir member, Dr. Cox, the assistant organist, and many others. Several of these had specific recollection of the days in question because they were memorable days. They were Pell's first solemn high masses as Archbishop at St Patrick's Cathedral. The High Court observed that they displayed general consistency, substantial mutual support, their honesty was not in question, and the High Court called it a powerful, quote, powerful body of evidence. And together, all of these testimonies suggested with remarkable consistency and in some cases specific clarity that firstly, Pell always stopped at the front door of the cathedral and spoke to parishioners as a matter of custom. Never less than 10 minutes, usually longer. And remember, these were his first 2 solemn high masses at St Patrick's, and so he was particularly in demand for people to talk to him. Secondly, Pell was always accompanied in the cathedral. It wasn't permissible for him to be left alone, especially when in his vestments. And he had to be accompanied to the sacristy to divest because of the ritual nature of that process. And this was all part of Charles Portelli's job description. Thirdly, the sacristy at any time in which the activity in question could possibly have occurred was an absolute hive of activity, with comings and goings and many people involved, etc. Now, the High Court observed that religious ceremonies follow solemn ritual. They're inflexible. And the memories of the witnesses were in some cases specific, including one who introduced his mother to Pell on one of the Sundays in question as he greeted parishioners. The court also noted that the alleged victims, if they had broken away from the procession as claimed, they would have in fact entered the priest's sacristy, which is the particular room in question where the assaults allegedly took place, once the servers were already in there, because they actually went around and took a longer route. And certainly there wouldn't have been 6 minutes of time. Back to the original point then, the question was asked, could this possibly be guilt established beyond reasonable doubt in light of all the evidence? And the High Court said, well, no. And they went further, saying there is a significant possibility that an innocent person has been convicted, as I said before. Now, that's a basic overview of the case, which I read in detail last night. Let me put it this way, and maybe this is more tangible for people. If we care about justice, it helps for us to think of it like this. What would this case mean if it were upheld? A single witness, more than 20 years later, no corroboration, extensive contradictory evidence, seeming implausibility. What if that reality could put a man in prison for the best part of his life and ruin him in every practical way? Pell has already spent more than 400 days in jail, most of which in solitary confinement. He's already lost his very senior role in the Vatican and so on. Now, the answer is very obvious. This is no basis for justice. This is no way to find and to uphold truth. It just cannot be permitted as a precedent. If it were permitted, then nobody would be safe from false imprisonment. The standard of proof would be so low as to be impossible not to satisfy. It should never have happened. And the fact that the Victorian Court of Appeal could, I quote, reason to satisfaction of the applicant's guilt by discounting a body of evidence that raised lively doubts as to the commission of the offences, that is a straightforward perversion of the justice system. To bring a man down not because it's beyond reasonable doubt that he's actually done wrong, but because it seems of who he is, because he's not well liked, because of other extraneous considerations. Now, I don't know Cardinal Pell. I don't know the alleged victim. I don't make any comment about the guilt or innocence of either, and yet I do know that the High Court has made the right call. Reading the decision, nothing could be clearer, nothing could be sharper. Now, before I move on, I want to show briefly how this rotten fruit, this really bad case, started from rotten roots. The Victoria Police, without any complaints, without evidence, started an operation called Operation Tethering. It was a police task force designed to find a crime and to find a complainant, neither of which it knew existed. It did so on the assumption that such things existed. Now, that's highly unusual. Barrister Robert Richter questioned Detective Superintendent Paul Sheridan over his operation at the Melbourne Magistrates Court in 2018, saying, Operation Tethering, that wasn't a Get Pell operation, was it? Superintendent Sheridan responded, I guess you could term it that way that you did, but I wouldn't term it that way. You know, by December 2015, so this operation was started in 2013, by December 2015, the Victoria Police actually advertised for complainants to come forward. A Guardian article published on December the 22nd bore the headline, Victoria Police Seek Victims of Sexual Assault at St Patrick's Cathedral. You know, eventually, after quite a bit of time, the police found their complainant. Then they charged Pell with, it seemed, no further evidence. And despite interviewing people whose testimony the High Court ultimately found compelling. And the matters raised by those who were interviewed right at the start ended up being the matters that contributed to the High Court's findings. And the alleged victim in this case I don't know if this person is a victim of sexual abuse. They may well be. But they're certainly a victim of a disgraceful police operation which amplified their pain by dragging them in to a witch hunt against a person and dragging them along every step of the way over years through a case that was never going to survive. It was never going to survive High Court scrutiny. And you know, something is really wrong in the state of Victoria. This is the state whose police force charges the peaceful victims of violent protests, like Lauren Southern, for example, $60,000 for their police services. Not the violent protesters, but the person who's been protested who's peaceful. It's the state whose police force has multiple times refused to send adequate resources to protect ACL events from violent protesters. I have stood outside events being protested where violence has broken out and pleaded with police officers to do something to stop people trying to access the premises and stop people blockading the premises and entering the premises. And they did nothing. And afterwards, when we sought to complain, they threatened to charge our supporters with assault because our supporters had to push through the crowd to get to the door, and they did nothing more than that. So again, who are the victims here? This is the state whose judiciary taints their judgment with the most basic of legal errors, getting the standard of proof wrong. There's nothing more basic than that, and this is the Court of Appeal. This is the state where Premier Daniel Andrews puts out a media statement saying, "I make no comment about today's High Court decision, but I have a message for every single victim and survivor of child sexual abuse. I see you, I hear you, I believe you." Now, of course, he is commenting on that day's decision of Cardinal Pell. He's saying he's not. But here's the thing, an accusation is not a proven fact. That's why the justice system exists, to find the truth. Not based on who said it, whether they assert that they're a victim, but based on what can be demonstrated actually happened, to try and find out who is actually guilty. But see, that's the principle that he articulates from the top. That this is about who you are, not about what you've done. Victoria is rotting from the head with a premier who is enabling a view of justice that is not based on the truth about a person's actions, but based on who they are. Lauren Southern, the guilty party, because she has right-wing opinions. ACL supporters, the guilty party, because what? Well, because they're Christians or something? They didn't do anything wrong. Cardinal Pell, guilty party. Why? Is it because he's a Catholic? What's going on? When justice is meted out based on identity and not the truth, there is no justice. Isaiah 59 says, truth has stumbled in the public squares. What's the result? Well, firstly, so righteousness cannot enter. There's no truth about what's right and wrong. And then what happens? Justice is turned back. Because, of course, if you don't have right and wrong, how on earth can you decide who's done right and who's done wrong? There's no justice. And that's what's at stake here. I mean, compare this with Cardinal Pell's own statement. It was released shortly afterwards. He said, "I hold no ill will to my accuser. I do not want my acquittal to add to the hurt and bitterness so many feel. There is certainly hurt and bitterness enough. However, my trial was not a referendum on the Catholic Church, nor a referendum on how church authorities in Australia dealt with the crime of pedophilia in the church. The point was whether I had committed these awful crimes, and I did not. The only basis for long-term, and this is the point, the only basis for long-term healing is truth, and the only basis for justice is truth, because justice means truth for all." And he goes on to thank various people. You know, without that timeless principle, justice will be meted out based on identity, based on belief, based on perception, based on irrelevant considerations and biases, and not the truth about what people have actually done. And if we get to that stage, there is no justice at all. It is that important, and there's something not right in what's going on in the state of Victoria, and this case is the latest demonstration of that. Again, I say this because I actually do care about justice. Justice for all, truth for all, whether they be accused, whether they be victims, whoever they are. Hey, one more thing. I've been looking at the metrics and I figured out something. You guys are watching the videos and not subscribing. So please help us out a great deal by hitting the like button and then hitting subscribe, hitting the bell as well so you get the notifications. It helps us out a really great deal, and you can click here to see more videos.